Township Zoning Hearing Board. We had hoped to do a presentation to Jim Dolan of his plaque for outstanding service today, but I think he must have been swamped with some last-minute issue now that he's not working in the area anymore. So I will present it to him at home, but I will go on the record as thanking him for his years of service to the township and the community, to the participation in this board. There's only one item on the agenda today. It involves a legal argument on a motion to dismiss the application of Radnor Properties, 201 King of Prussia, KOPLP, Radnor Properties, well, as a bunch of Radnor Properties entities, in regard to the property located at 145 King of Prussia Road, known as the Biomed Property, which is zoned PLO. And this was filed as an appeal to a determination allegedly made by the Zoning Hearing Board, with that issue being one of the issues in question, whether or not there is a determination in the technical sense. What I'd like to do is, first, I'd like to get one thing clear. In making this decision, we are going to assume the fact, based upon what was said last time, that Biomed and the township have agreed with each other and in front of this board on the record that they both consider this letter that's in dispute as not a binding determination, that really is something that has no legal effect. Does anybody disagree with that?
Let me just address that for a minute. Nicholas Cornelia for Biomed. Our Biomed's position on this is that the zoning officer, as you know, made a determination. That determination was based on whether it could be 100% offices. Right now, it's percentage offices and a certain percentage research lab. Zoning officer stated that provided you provide the parking and things of that nature, you can do it. But that was not a final determination. Obviously, a final determination cannot be made until there's full plans that the zoning officer or the township can rule on, whether there is a permit or a land development application. So our position really is that it would be a nullity for the zoning board to make a decision on the zoning officer's determination because the matter's not ripe. The only way it becomes ripe before the zoning board is if there was a permit issued or a land development plan applied for by the applicant. And that has not
well, I
occurred
wasn't
yet.
going to go into the argument.
Yeah, no, I just
yet.
want to say I'm kind of trying to.
What I'm trying to figure out is your client, is Biomed, we'll call them Biomed, is your client going to take the position or not that there are some rights that have accrued to them by virtue of this letter? Or is it a nullity? Are we starting?
Well, I guess it's the term when you say nullity. That's where
without prejudice to any party. In other words, it has no effect. It doesn't necessarily negate what was said in that letter, but it doesn't necessarily stand as anything that will ripen into a right or into an estoppel or into anything else.
It would not ripen into a right. Brandywine would have a right to appeal upon the issuance of a permit or a land development application. So in effect, because full plans have not been issued, and the difference
But you're going to one of the ultimate facts and issue, Nick, and we're not there yet. In other words, before we get to that, we're trying to figure out if there's any possibility that we have to consider in our decision that your client will take the position that this letter has some efficacy from a legal standpoint, either against the township, against neighboring parties, or anyone else who might have an interest in this or be aggrieved by it.
The efficacy that it would have would be if Biomed filed land development plans and showed that they're converting some of the research and development space to offices, that is allowed provided they meet all the other conditions in the land development and zoning ordinance.
Are you taking the position that it's by virtue of that letter that's allowed, or by virtue of the language of the ordinance and the classification of the property?
Well,
and prior approvals.
It's
a very important issue for us.
It's by virtue of the ordinance, as the zoning officer has also agreed that it's by virtue of the ordinance. that is permitted by right.
Mr. Cornelia, I'm a little surprised to be hearing this because I thought it was crystal clear on the record, both from the Township and from Biomed last time, that this letter is an advisory opinion. It is by virtue of by virtue of that position being taken by the Township and Biomed, we have nothing before us. If there is something that may change the playing field later, then it seems to me that that argues for an appealable event right now. I mean, to me, the only issue in this appeal is whether an appealable event has occurred. I've looked at the standing issues, and I've advised the board that if an appealable event has occurred, Brandywine clearly, unequivocally has standing, and because an appealable event has occurred, and they're close enough proximity to be aggrieved by it, and they share more than just the common interests of Radnor Township residents generally. But one thing I had, we had talked about last time was if the motion to dismiss were granted, it would be I would recommend to the board that it be absolutely crystal clear that this letter does not prejudice Brandywine's rights in the future, that it is not an appealable event, and indeed cannot, with the occurrence of subsequent events or the passage of time or anything, ever ripen into an appealable event. You'd have to get another letter.
John, I totally agree with you, what you just said, that it is not an appealable event. It does not ripen into an appealable event.
And cannot ripen into an appealable event.
Cannot ripen into an appealable event.
If you ever want to give
until a permit or a land development plan is approved. Then it becomes an appealable event by either us or by Brandywine.
No, not what I was saying, and maybe I didn't make myself clear, is the letter is a nullity. It can never become an appealable event. If you want an appealable event, you've got to get a permit or get a letter in conjunction with an application. This piece of paper is gone.
Yeah, well, see, when you say a nullity, if you look at the cases, particularly, I guess it's the Dower case everyone's quoting, nothing in there says the letter or determination was a nullity. What it said was it was not an appealable event, that it only becomes an appealable event if there's a building permit issued, if there's a land development plan issued, or in the Dower case, whether there was an enforcement action taken.
Yeah, I'm very uncomfortable with that because one of the cases cited by Brandywine, the Amin case, was a situation where there was a letter and they held it was an appealable event. Now, in that letter, they said that it was appealable to the zoning board. The zoning board treated it as an appealable event, even though accompanying varying request was withdrawn. The trial court was the one that interjected the jurisdictional issue, and the Commonwealth Court reversed. But in that case, it seems to me that there was a real issue. I mean, Brandywine should not be in any worse position at all, period, as if this letter had never been written.
Can I speak to this?
Go ahead, Peter.
The township's position is that this letter will never ripen into an appealable event, that it does not affect Brandywine's status one iota, and that Brandywine's appeal or failure to appeal this letter has absolutely no effect upon their ability to appeal later approvals or permits that are issued in conjunction with any plan that Biomed proposes on this site. Absolutely, positively. It has no effect whatsoever. As to Brandywine, the letter is a nullity. It has absolutely no effect.
And can never, ever...
And never, ever, ever...
become a real thing. You have to
Correct.
get a new letter.
Correct. Well, no, you have to get...
Or a permit or something.
You have to get a permit, you have to get approvals. And that whatever a permit or approvals are granted, an appeal from that approval, from that permit, is going to be based entirely upon the plans and applications submitted to gain that permit and approval. It will have nothing to do with this letter. Now, the township might reach the same decision as is stated in this letter. It might say these plans are exactly the same as the plans that were submitted for this letter and say they meet zoning, but they can still be, that decision can still be appealed,
Yes.
regardless of what happens here.
Yeah.
And in fact, it's our position that even if you decide to go forward and act on this letter, that your decision will have no effect whatsoever on what the township would later do when a plan is actually filed, because the plan stands on its own.
What I do want is to, I do think Brandywine is entitled to, is that kind of an unequivocal assurance. And this is, I don't know how the board will actually vote, but if the board were to vote that we don't have jurisdiction, I think in part that comes from the assurance that I thought we had last time, and I hear you saying now, that this letter is a nullity. And if you wanted to, if there was ever an appeal on a
Well,
letter.
I think there's a distinction to be made. I think the only one using the word nullity, the only ones are you and myself here, John.
Well, no.
And I only see one difference. I think the only difference between it being a nullity and what you're saying is whether you would possibly claim that this somehow forms the basis for an estoppel.
There
Because right now, we're talking about the township taking
Right.
some action from which an appeal may be taken by Brandywine
Right.
in the future based upon an application that may be made or an
And that's
approval
why
given.
my distinction is here. This appeal was brought by Brandywine. It was brought by them because they're worried that if they failed to bring it, they would somehow waive any right to question this particular decision in the future. It's the township's position that absolutely positively failing to bring this appeal would not cause any sort of waiver. Now, as to between
Yeah, I want a
Biomed
clarification
and the
from you, Nick,
township-
then. Do you agree with what Peter said?
All right, I want to
Now, what
clarify-
about the estoppel issue,
Excuse me,
though?
no. Can I ask one question? You were pretty precise. You said, as to Brandywine, the letter is a nullity.
Correct.
Are you making a distinction regarding the status of the letter as to Biomed? Is it a nullity as to Biomed also?
I think Biomed could possibly bring an argument that if we changed if they, relied on that letter and then we changed our position, that they would have some sort of argument, as you put, maybe estoppel. But that's only between Biomed and the township. No other party, be it Brandywine or any other party in the world, could make that argument. Because only Brandywine could possibly rely on the letter.
Question, does
Has
that
there
put
been
Brandywine at
reliance
risk, though?
What?
Does that put Brandywine at risk?
Absolutely not, no. Because Brandywine can always appeal.
So let's say Nick were to make an argument in the future that he's got an estoppel, and we all have our own opinions as to whether you'd have the basis to do that, but let's just say you did. At what point would Brandywine have notice and be able to protect his interest?
Whenever an approval is granted, Brandywine can make that, appeal that approval and make whatever argument they want.
So if he argued estoppel and you granted a permit, they would take an appeal?
They would take an
you
appeal.
denied the permit, he would take
And
it.
at that point in time, they could argue that this zoning determination was wrong, the township made an error, provide the evidence why we were wrong, and if Brandywine can prove that we were wrong, we're wrong, and the approval is thrown out. It has no effect on what argument Brandywine can make. Absolutely none.
I mean, the fact that there's.
And let me just be clear. I'm not saying Biomed even is correct that they could bring that argument. I recognize that's an argument they could possibly bring. I am not at all saying or admitting or agreeing that that is a winnable argument.
Right, but I'm trying to figure out, is this something that anyone is likely to face? Is that the thread you're holding on to when you say you agree with Peter, but you're not saying it's a nullity? Is that the thread? Are we talking about the estoppel thread?
Well, it's more, again, in the cases, I don't see anything regarding a nullity. A nullity would mean that his opinion that we're permitted to put offices there is.
Nick, we're not arguing the case here for now. We're not
Yeah.
arguing the cases. What I'm just saying is, nullity is the word that we are using just to say this has no effect, everybody agrees it has no effect, and that's the basis on which we're hearing this argument and making the legal decisions. Now, if you don't, I want to know in what way you're saying it's not of no legal effect. Forget the word nullity.
Yeah.
I don't care whether that's in a case or not right now. I'm just saying, are you going to claim any legal effect as a result of that letter? Not what's in the letter, not what you asked for, but in that particular letter.
The only, as Peter mentioned, if we filed for a building permit application And I'll give you an example. We file for a building permit application, and the township now says that, wait a minute, you can't put in 100% offices. And relies, and basically saying, not because you're in violation of any zoning ordinance, but we kind of retract our previous opinion that you can't put in 100% offices. And the other way, legally, I believe they could retract that would be if we didn't comply with the zoning ordinance in some other respect, in some other regards. So, to some extent, yes, we would rely on the zoning officer's letter that we could put in 100% offices, but we're well in front of that right now because we would have to have detailed plans showing we comply with all the township ordinances. And at that point, if a permit was issued or denied, then we would have a chance to appeal, and Brandywine would have a chance to appeal.
Or would your appeal
as
be
well.
based upon the contents of that letter? Or would it stand on its own 2 feet, based upon the facts and the code?
No, I really
Okay,
don't know.
well,
At this
then-
point, I can't really say.
Then John and I
whether or
both
not.
have a bad memory of what was said last time because we thought very specifically that both the township and Biomed agreed that everybody could go forward with the assumption that that letter was not going to have any legal effect, that we were wiping the slate clean. But apparently it's not Biomed's position.
No,
So we have to
think-
consider that and how we deal with
Again, yeah,
our
you're
decisions.
talking about what the legal effect is, Noah. I mean, again, it's not an appealable event. And Biomed has not relied on that letter to date. I think that may have been
That's
John's
the question that I was heading to, and
What are you holding on to? What's the thread? If you just said that you haven't relied on it, what is the thread? You're saying it's not an appealable event,
It's not an appealable
and you're
event.
saying that you haven't relied on it, which keeps you from alleging estoppel.
But
not-
he's
Yeah,
not
and
saying
to
that they
this
might
extent,
not rely
yeah,
on
we
it
may
in the
not rely-
future,
yeah,
and
in the
that's a
future,
different
right,
issue.
right.
So my question really is, to the extent that the township wanted to retract the letter now, before Biomed has relied on that letter, would the township be able to do that?
I don't know. I mean, would they be able to retract the letter and say that?
You object to the retraction, I think is
That
what
it
John
was
said.
ultra vires, that
I
it
would-
was
I would-
injudicially
yeah,
considered, call it what you care to call
I would
it.
object to a retraction of the letter, yes. I would object to retraction.
But
of
if
the
it's an
letter.
impermissible advisory opinion, which is what your brief and the township's brief says, I don't see what you're giving
No, John, I
up.
didn't say it's an impermissible advisory opinion in my brief.
It's an
What-
advisory
What I stated is not right for appeal. It's not right for appeal by us if he denied it, according to the Dara case. It's not right for appeal by Brandywine or an opponent. And that's the issue, really. Is this right for appeal or not? And the cases are, again, without arguing it,
I think, okay, we're beating a dead horse and getting into the argument. So then all I'm going to say is, then we are going to leave that issue open and undetermined for the purpose of our considering what's about to be argued, what's been submitted in the briefs we've already received and read, and in rendering our decision.
Would it be
Could I
possible?
just make a comment on that, too?
Sure, George.
Well, let me just ask one question. I mean, one possibility is to grant the appeal on the theory that it's an advisory opinion and can't have legal effect. And if we're having arguments that it does have some legal effect, why shouldn't the board simply grant the appeal, not get to the merits, and just say it was an improvidently, it was an impermissible advisory opinion?
Because there's nothing prohibiting Mr. Krasinski from giving his opinion on whether or not something complies with zoning or not. If someone comes up with him and asks, hey, do you think this complies?
Peter, if you, Mike, please.
He has the right to give his opinion. If at a planning commission, someone asks him, do you think this particular aspect of a plan complies with zoning? He has a right to give his opinion. That
But
is-
do people have a right to rely on what he tells them in that situation?
When it's a non-appealable event.
That's the question.
That's the, I think that is
Yeah.
what Nick is arguing, is that he thinks
I
he
mean,
might be able to. I'm saying, I recognize that could be the possibility, but I'm not saying that they can, and I'm not saying that, Nick can make an argument based on promissory estoppel that he has a right to an approved plan. It's actually, that my opinion is, as I stated before, a plan for approvals or for permits, any application for approvals or for permits, it's going to stand on the four sides of that applications. That it relies on what was submitted to the township as part of the application, being the plans and whatever other reports are being submitted, and that's what the township issues the approval or the permit on. And therefore, the appeal of that approval or denial of approval is going to be based on what's submitted, regardless
Yeah.
of not this letter.
We're aware of this, and the question is whether we had to consider the fact that there is possibly some effect that's going to be asserted of this letter or not. It just is going to bear on how we interpret what we're about to hear and what we've already read and studied. So we'll get to more of that in the argument itself. I mean, everybody's kind of making their arguments yet, and George hasn't gotten to speak to any of you. Actually, you don't have a dog in this race because the question of whether they both agree to consider it a nullity is really not your question.
Well,
Because, you know,
I think that's a
it may
huge
affect-
issue for us, actually.
Yeah, well, that's right. It may be, but I'm just saying, as a matter of fact, on which we're going to make this decision, as an input of fact, along with everything else we're going to hear and consider, that's an important question. And, you know, they're the parties to the letter, and they're the parties that can say we're both going to claim no effect of this legally.
Right.
You really don't get to say that because you don't really have any benefit or detriment from that letter unless, of course, the letter has some enforceability.
Right, we have a detriment if it does. And I won't
Possibly.
belabor it. I think the board members, from the questions that I've heard, are picking up on the exact issues we've been afraid of, quite frankly. And
Are you starting your argument now?
No, I just want to address this point. I just
What?
want to say that it was very clear to me that both parties last time were saying, this is a nullity, why are we all here? It is very clear to me tonight that that's
I gave
not-
you a chance last time to say that if they agree to that, this all
Right.
goes away for now, and you'll dismiss the appeal, but I believe you didn't take that opportunity, so...
Well, I need a
this is-
ruling from the board. I couldn't dismiss my appeal. I need a decision from the board, and that was my position last time. But I'm hearing very loudly and clearly, especially from Biomed, that, you know, they don't agree that the letter is a nullity. And even Peter is saying that as to Brandywine, it's no effect, but nobody's saying there's no effect as to Biomed. Well, if there's an effect as to Biomed, we're an aggrieved party, there's certainly an effect to
Well, I think it's
Brandywine.
certainly reasonable to say you could be an aggrieved party. We don't know.
Right.
You could be by that. And that's that possibility that we were exploring.
Right. If
So we
there's-
understand that now as the basis
Right.
on which we're going to hear this. Now, before you start your argument,
Yeah,
you may
I'm
as well
not
stay
gonna
at the
start my
podium.
argument.
Well, you're going to be first, so you may as well start it. But we intend to limit this argument to 10 minutes per party, because we've already read the briefs, had our advice from our solicitor on the briefs. The cases have been read and checked and discussed. So we're going to limit to 10 minutes. Then if anyone needs a rebuttal time afterwards, we'll let you have a minute of rebuttal time if you feel you need it. I'm not encouraging you to take the full 10 minutes or to rebut, but you do have the benefit of that. After that, I think it's going to be wise, especially in light of this development, that we will then take a break, and we're going to have a little caucus to receive further advice from our solicitor on what we hear today and what we now know. And then we're going to come back out and consider this on the public record and render our decision. So,
Mr. Chairman, since I'm not voting on this matter, would you like me to keep the time?
Sure. Good idea. You have an accurate watch?
I have an iPhone.
Good.
How much did you say we get?
You get 10 minutes.
Okay. And you
And I have a hook under the desk.
You want me to go first? It's Peter's motion, or?
Well,
Whatever.
do you care, Peter? Excuse me, Peter, do you care if he goes first?
No, it doesn't matter.
Since he's actually, I realize it's on your motion, but he's the actual moving party on the application, so let him state his, and the more time you can spend on things you haven't already educated us on in your briefs,
Sure,
the better we'd like it.
I appreciate that you've read the briefs. I'll try not to be duplicative, but I just want to get some things out. Of course, I'm George Brosman, representing the Brandywine entities. To highlight the determination, because I think that's the key here, is what kind of determination do we have? Just to highlight it, we have a determination that a new 102,000 square foot plus office building that is 42 feet high and that has a length of 265 feet is permitted when the zoning ordinance allows 38 feet high and 160 feet long. We have a change in a use of a 228,000-foot building from lab to office, and we have construction of 515 new parking spaces. Now you say, or you might say, well, how could that be permitted? How could Mr. Kachansky make a ruling that that would be permitted if it violates those things from the zoning ordinance, the height and the building length? The claim is that the zoning board in appeal number 2758 granted those approvals, and they're going to use those approvals here. And the determination, I believe, was that that plan, which was a different plan than this plan, now those variances can be used, despite the fact that the zoning order said that the approval was in the precise manner as shown on the plan submitted and in the precise manner as shown in the testimony and other exhibits. And that's a standard condition that this board has been pretty strict about. So we have a totally new plan here with a lot of building on it, and they're trying to piggyback on this. And they went in, and
George, we're not, we're not arguing the merits of the case now.
No, I know. I'm trying to, one of the issues is there a determination? And I'm trying to describe what the determination was.
I mean, we know what the letter says. We've read it many times.
Okay.
And we know that you don't like what the letter says. You'd like a shot
Well,
at
I would
that.
like to, I'll try to be
But
brief.
today, we're just talking about whether there's standing, which we feel.
I'll try to be
there is.
brief. I think it's important to, if the question is the determination appealable, to just go over what the request was and what the determination was, and I'll try to move through it quickly. You have in the package, there was a filing fee paid in accordance with the township fee schedule. A letter was submitted, and a plan was submitted. And we keep hearing, well, we're speculating, we're asking for an advisory opinion, we don't know what they're going to do.
What was the fee for? What was it paid for? What kind of fee is it?
It was for the zoning determination. The letter that I have here, we can put it up on the screen. It's a $100 fee. It says, the letter says, I don't know if you'll pick that up, or I have copies. It basically says they're filing an application, they're filing a plan, and they're paying the fee.
I think they've zoomed in there. There we go.
It says we're submitting a zoning determination sketch, we're submitting plans, and we're submitting the check-in amount of $100, the required fee. We hereby request a determination on the attached plan. And then there was a plan. We're not speculating about anything. There's a specific plan. Just to highlight it, proposed 3-story building. The height is 42 feet. The distance, the length is 265. There's 862 parking spaces today. They want to build 1377. There's a 3-story underground garage that is proposed. And there's specific plans filed for that. And so we say, we're not the ones speculating and asking for advisory opinions. A plan was filed. We shouldn't assume, or nobody should assume, that they're not going to build this.
George, I can't see the detail. Does that plan show an office building or a lab or a mixed-use building? What does it show?
Yes, proposed 3-story office building with underground parking. That's in the parking detail. And here, proposed 3-story office building. And then it shows the parking being calculated as if all buildings are converted to office. And it's got the proposed building square footage, it's got the parking. And so the plan is to build this new building, to build this parking garage underneath, this 515 new parking spaces, 862 exist, 1377 are proposed.
So this is for a different project than was approved before. That's your position?
That's our position if we get to the merits. So they go to the zoning officer, they file that letter, they get the response, which you've seen. It's clearly, he makes the determination they ask for. just to highlight a few things in here. He's talking about, I have received and reviewed your letter requesting a zoning determination. Comment 4, he's talking about reviewing a submitted plan. Comment 5, reviewing the plan. Comment 6, he's indicating he's checked out the new parking spaces. And in the end, on page 2, it is my determination the conversion of the buildings on the site with the improvements as shown on the plan to 100% office is permissible in accordance with our ordinance regulation. So then I go to the MPC. This is the jurisdiction of the board. It's in our brief.
It's upside down, George.
Oh, I keep putting it, whatever way I put it is upside
Can
down.
you scoot it over that way? Yeah, thank you.
So appeals from the determination of the zoning officer, including but not limited to the granting or denial of any permit. So I think we clearly have a determination. We have an application filed for one with a plan, a fee paid, and a determination issued. Now we hear that we have to wait until there's a building permit granted, then that's when the appeal should come. I think that is totally incorrect because this language would mean nothing in the ordinance. It says including but not limited to the granting or denial of any permit. So it's obviously broader than that. And the word determination is used. We also hear that, while they might have to go through land development approval, I don't know that the township is going to require that. You would hope so. But assuming they would require land development approval, you have to wait until a land development approval is granted. Well, what we're hearing from Biomed is that they may well take the position at that time, yeah, we're in for our land development, but we got our zoning determination, so those issues are off the table. And the cases that, that Jenkintown case that's in Nick's brief, it actually talks about that the authority of the zoning officer is distinct from the authority of the commissioners.
2 minutes.
Thank you. In a land development proceeding, it's the zoning officer that has the power to say whether the zoning issues are met, and that's separate from the commissioner. So what we're afraid will happen here is they'll come in for that land development approval, and we hear what the argument's going to be. We haven't relied today, but now we've relied. We've done all our plans, and that's going to be the argument, that the zoning officer made a ruling, and that should have been dealt with then, but now that's the law of the case, if you will. Even in the North Codorus case, a similar thing happened. That's where there was a land development plan pending, but during the plan, the engineer called up the zoning officer and said, which ordinance is going to apply here? The zoning officer said, well, the new ordinance. Didn't even put it in writing. The landowner appealed to the zoning board and said, I'm appealing that determination. They didn't wait till the end of the land development process. The zoning officer had the authority to make the ruling. He made the ruling, even verbally, and the court said, yeah, that's a determination. The zoning officer has that power. You didn't wait till the end of the land development plan to make that, and he had the power to do it, and there was a power to hear it. And the Joe Dara case, I've addressed it in my brief. I think that's the only case that was cited that didn't involve a substantive validity challenge. There's a special part of the law for that. Substantive validity challenges do say you have to wait for a building permit, but other zoning determinations, you don't. And the Joe Dara case was a different animal. They didn't ask the zoning officer for a determination. They had piles of junk they were storing, and the question was that in violation of the junkyard ordinance? I'll just be 30 seconds. Was that in violation of the junkyard rules and the zoning ordinance and the...
We don't need to use your time for that. We've read the case.
And rather than ask whether that violated, they just said, well, reclassify me, and they went to the zoning board and asked that. So that's different than what we have here. So we would ask that you deny the motion and allow us to proceed to present our case on the merits. Thank you.
Anybody want to go next?
I'm not going to deal with the merits. That's not before this board. What the zoning officer stated was that despite, there was one paragraph in there saying the steep slopes were man-made and permitted, and that they can convert it to 100% office. There was no final determination made by the zoning officer because he did not have a land development plan or a permit plan in front of him. Once he makes the final determination, that is an issuance of a permit or a land development plan in front of him, a formal land development plan, it is then an appealable event. When it becomes an appealable event, Biomed, any party can then appeal it, whether it's the landowner itself or an aggrieved party. Until that time, it is not ripe for decision, and as been cited in all the briefs regarding advisory opinions, until that time, it is just an advisory opinion for the zoning board to make determination on it. That's why the zoning hearing board does not have jurisdiction on the matter until a permit application is made or a land development plan is approved or some other active item occurs. There's one case in the brief where the zoning officer gave permission of someone to move a nonconforming use to another location, and that person moved the nonconforming use and the neighbor appealed it because actually there was some action taken on it. Now, the other thing that Biomed could have done, which could have locked out Brandywine, or at least they would make it an appealable event, is filed under 916.2 of the zoning hearing of the MPC. That provision provides that after the zoning officer makes a determination that a landowner requests that the matter be advertised and that any opponent would have 30 days to appeal the decision. That would make it an appealable event. Biomed did not proceed under 916.2 of the zoning code. So as of right now, basically we have no appealable event. The zoning board has no jurisdiction. Brandywine is not waiving any right. When a land development plan is filed or a permit is issued, Brandywine has the right to appeal that event, that determination. Until that time, the matter is not ripe, and the cases are consistent, throughout all the briefs that when a matter becomes ripe for appeal. It is when a final determination is made, and that final determination involves a permit or a land development plan. That was not done here.
Excuse me, Nick. You used the phrase a bit ago, advisory opinion. Is an advisory opinion binding?
It is not binding. It's an advisory opinion.
Then how could it bind the township at a later date? I mean, one of the things that bothers me is that if the township is somehow going to be stopped or face estoppel at some future time on the basis of this letter, then doesn't that prejudice Brandywine's rights to litigate freely because somehow the township is knocked out of the box on an estoppel theory?
No, they still would have the right to appeal the actual merits of the application.
Yeah, but not in conjunction with the township. I mean, I'm bothered.
Yeah, they're not harmed at all, John, by waiting until a permit is issued. They still have an appealable event when a permit or land development plan is issued. There's no, the estoppel argument, if it is made, would just be between Biomed and the township. Does not have any effect on Brandywine's rights to say that the decision, even the original decision of the zoning officer, was improper.
I just, it would make, to me, it is very relevant as to whether there can be any change in the status quo. We're saying there's no appealable event. is being, I suspect, although I've not been following it, that this letter has appeared in the must ordinance proceedings, and that's a legislative debate. And my own personal thought is that the zoning board should stay out of a legislative debate. People can say what they want, they can advocate, and so forth. But I am a little bothered by the assertion that there might be an estoppel against the township, because that may tilt a future litigation playing field against Brandywine.
See, that's where I disagree, John. I don't see how it tilts anything against Brandywine, because they have the same rights, based on the issuance of a permit that they would have if you granted them these rights now. It's not affecting their rights. If there's an estoppel argument between Biomed and the township, it has no effect on Brandywine whatsoever. Brandywine can appeal it. They're not subject to the estoppel, and they can appeal the issuance of the permit on the merits, saying it doesn't comply with the zoning ordinance or past decisions or anything of that nature. It does not stop them from doing that.
Well, right now, we're in a situation where you've stated that there is no reliance right now, but that reliance somehow could happen in the future. Personally, given how hotly contested this is, I don't know the reviewing court would look favorably. But still, we have to pay attention, in my view, to is Brandywine's, it has the right to appeal freely and so forth and so on, but is their position going to still be subtly altered to their detriment by the fact that the township is not able, or is may not be able to participate freely as a free actor at that point?
The decision by the zoning officer was that they could convert it to all offices, provided they meet the zoning code, other zoning code requirements.
Actually, it said that the plans complies with all zoning code requirements, if I remember correctly.
Right. So, and again, if you look at the cases, it's clear when an appealable event arises. There was some mention by George regarding North Codorus. The difference there is that a land development plan was actually filed. It was appealed by the owner, and there was a specific plan, a specific land development plan filed there. The Amoon case that was cited, it was a situation where the ordinance, the township ordinance, actually permitted the applicant to file a request, and in that instance, there was a statute similar to what I stated was 916.2 that permitted the landowner to get and solidify, lock in his rights. And that's where an appeal took place, and the ordinance specified what can actually occur there. As I keep on going forward with this, and particularly if you look at the Dara case, the Joe Dara case, in that case, remember, they were asking for some sort of change or change in classification.
2 minutes.
But the Dara case did not render a determination by the zoning officer a nullity. It stated that it was an appealable event, but they didn't have jurisdiction because it wasn't ripe. Again, it all goes back to the ripeness and when does ripeness occur. And it's clear in all the cases and in the statute that a final determination has to occur for that to occur, and that it only occurs when there's a permit issue or a land development plan approved. And I disagree that they're being harmed, that Brandywine's being harmed by this.
Nick, do you think the letter, the township letter of October 4 from Kevin, does that constitute a determination?
Not a final determination. A final determination that's an appealable.
And the definition of determination is final determination. That's how it's defined in the statute.
And one other question, Nick. What would you describe the implications of your client's engineer submitting the $100 fee with the letter?
It's required by the township that when you ask for an opinion from the zoning officer, you have to submit a fee for $100. It's done commonly when, before you have a zoning application, you ask the zoning officer, what relief do I need? Here's the plan. It's done very commonly. Again, that's not subject to appeal until you actually go before the zoning board and argue that the zoning officer erred in that determination.
And those kinds of responses would similarly stop the township, as you would be arguing that this one would be?
The question would be, would the zoning board be able to overturn the decision of the zoning officer, which obviously, it could.
Thank you.
Nick, your time's out, but I want to ask you a question I'd like you to respond to, and that is the plan that George put on the table that was submitted with this fee and this request for determination. That is not the old plan. You agree that was the plan for the project that is intended to be built. Not necessarily a full land development plan,
Right.
but a preliminary plan, certainly more than a sketch plan even.
Well, it's probably more of a sketch plan, though. I don't think it went into the details. A land
But it
development
was on the
plan
project
involves-
you intend to build. It wasn't just the old plan of the
Well,
property.
let's put it this way. There's never been mention that Biomed intends to build this project, that there's been no development plan filed for this project, and there's never been any mention that Biomed intends to build this project. And I
The
think that was
determination
stated in
was
your
relating to that plan. It says it.
The determination was
It
related to
says it
that
very
plan.
specifically in that letter that it was a determination of doing things that are in that plan, that they are okay with zoning, that they're okay with the grading, things like that, to the extent that they're shown on that plan. It was specific to that plan. It wasn't a general statement of, yes, it's zoned for this and allows that use.
I would agree with that, but again, it was not a final determination
Okay.
made by the zoning officer.
All right, thank you. Peter, you're at bat.
Thank you. Peter Nelson on behalf of Radnor Township. Just let's address the estoppel issue first. I think this has really muddied the waters here. The estoppel issue has nothing to do with any future plan or permit approval. Absolutely not. The township cannot be prevented from approving or denying a plan based on estoppel. A plan, a permit application, land development approvals are granted and denied on whether or not the submitted information complies with the township's ordinances. That's it. Nothing more, nothing less. The
So if-
estoppel has nothing to do with that. Absolutely not. I completely and totally disagree with any statement other than that.
So you would say that, while you're acknowledging that at some future point estoppel might be alleged, your position would be that they can allege it all they want, but they wouldn't get it.
Not for,
Shouldn't get it.
not on, if they want to allege it on the basis of the township has to approve a plan or grant a permit, no, that would not be supported. What the estoppel could come up in is if I could see a situation where they try to allege estoppel outside of some sort of plan review approval. If they sell the property, buy the property on the basis of what the township told us, and then the township says something new to the buyer, it would be a civil action in front of the Court of Common Pleas. It would not have to do anything with plan review, permit review, plan approval, land development approval, granting of permits. Absolutely not, nothing.
But let's say the township refused a plan. They ultimately submitted a plan, requested a building permit or a land development approval, and it was denied on the grounds that it did not comply with X part of the zoning code. And in fact, this letter, let's say, says that it does comply, that this issue does comply with the zoning code. Wouldn't you then have to grant the permit or be sued?
No,
And how would Brandywine participate in that granting process if it's a litigation between the township and the landowner over whether the township was stopped from raising an argument that it otherwise would have been allowed to raise under the code?
No, because any approval or denial of a plan or approval, there's a set process that the appeal occurs. The appeal is made to the Court of Common Pleas, and in front of the Court of Common Pleas, the standard is
And what
whether-
if Nick's client wins that appeal and you have to grant that permit? Where does Brandywine get a
Well,
chance to object to that?
If Nick appeals it, Brandywine has the right to participate in that appeal. once the permit is granted.
But the appeal issue was the estoppel, not the merits of the
But they can't, the
project.
appeal, our position is that the appeal issue couldn't be the estoppel. If Nick wanted to appeal a denial of a permit, he would have to prove that whatever application they submitted complied with all the applicable ordinances, regardless of our estoppel.
Mr. Nelson, can I just ask one quick question? If an order were to be issued by this board holding that this is an advisory opinion and a nullity for any and all purposes, would the township object to that language?
No. It's our position. This is an advisory opinion. They asked to get a reading of the tea leaves. The letter doesn't say that as most other appealable issues, when the township issues a written correspondence that is appealable, at the bottom of that correspondence, the township puts, you have a right to appeal this to the zoning hearing board in 30 days.
I think one of-
And this letter specifically does not have that language.
Yeah.
If you look at the language in the case cited by Brandywine,
the Amin case?
what?
The Amin case?
The Amin case, which is an unreported decision.
Yes.
That letter specifically stated that it was appealable within 30 days to the zoning hearing board. That letter was issued under the specific process of a preliminary opinion, which explicitly, the purpose of the preliminary opinion is to cut off appeal rights by third parties. This process here, what Biomed tried, what Biomed applied for, was merely trying to find out, okay, this is what we're thinking. Kevin, what do you agree that this complies? If not, let us know where it doesn't.
I guess
it has nothing to do other than to kind of give them an idea of where we stand.
Personally, I think the Amin case is the most troublesome. I think North Codorus is distinguishable because there was a land development application already present, a specific development being pursued pursuant to an application, and in Collis, the land use had commenced on another piece of property. Action had been taken following a favorable opinion. The Amin case did involve an application to a zoning board, coupled with a variance request and an overturning of the interpretive decision. The zoning board, for some reason, the applicant pulled the variance request. The zoning board denied the interpretation, and the trial court, on its own motion, took the position that that was an impermissible advisory opinion and was reversed by the Commonwealth Court. But in that case, one thing that I think is pretty clear, at least from the facts that are reported, is the township always treated that as a determination. Otherwise, I think Amin is very difficult. It also was adverse to the landowner as well, and that's a distinction. But I mean, my thought is, again, if people want to cite this letter or cite other arguments in a legislative proceeding concerning the must ordinance or anything else, I don't. I'm hesitant to get for the zoning board to involve itself in a legislative matter. But if it's changing the playing field in any other way, that's a different cat. But the township would not object to an order that said that this is a nullity and that there's no possibility of estoppel, ripening. It can never amount to anything that would change the playing field right now.
Yes, as I said before, yes, we wouldn't have an objection. I mean, just this determination it's advisory. It's academic. If no matter what you do, if you hear the merits on this case, if this board hears the merits on this case, it has no effect, practically speaking, on what's going to happen on this property. Because Biomed can do nothing on the property without submitting further applications to the township. Further applications that would reach a final determination that would then be appealable. This letter grants Biomed no rights whatsoever. They have absolutely no right to go on the property and do any work on the property. In order for something to be appealable, that event needs to create some sort of actionable acts, that can be carried out on the property.
2 minutes.
This is merely Kevin saying, this is what I think, but it grants absolutely nothing to Biomed and does absolutely nothing to Brandywine's position to oppose any future projects on the property. As Biomed said, and as there's absolutely no evidence whatsoever that Biomed ever intends to act on this plan. No evidence whatsoever. And if they did, they'd have to submit something further. They'd have to submit fully engineered plans, further reports, pay further monies to the township, and those plans would be reviewed completely independently from this letter. This letter, from a legal standpoint, has no effect and does nothing to hinder Brandywine's any future opposition to Biomed's plans. The definition of a determination in the MPC is that it must be a quote-unquote final action. This is not a final action. This is the first step. The final action is when the township grants that final land development approval, grants that building permit. That's the final action. That's what's appealable. Furthermore, as in the one case, the Collins case, where it was a verbal decision that was appealed, that was a final action because that verbal decision granted the landowner the right to move his non-conforming junkyard from one property to the other. And the neighbor who lived next to the property he was moved to was the one who appealed it. Clearly, there was a final action. There was acts that took place based on that final action, and that's what led to the appealable event. In this case, there is nothing. Nothing can be done based on this letter. And furthermore, that's why Brandywine is not aggrieved. Because no matter what happens with this letter, it has no effect on Brandywine. Brandywine has alleged that, it's going to lead to further traffic, further noise, greater density of office space on the site. That's absolutely incorrect. This letter does none of that. Those things only can occur once Biomed actually submits a plan that can be fully reviewed and approved. And lastly, the question regarding the plan. The plan that was submitted doesn't even meet the requirements for a sketch plan. They took an existing plan, hand drew some stuff on it, and said, what do you think about this? Even a sketch plan in front of the Planning Commission is usually better engineered than something like this. This is a step up from a sketch on the back of a napkin. Thank you.
Can I have a couple minutes to respond? I'll be brief. Just want to hit a few points. There seemed, in my mind, the issues are being confused here. We don't dispute that further approvals would be needed to do this plan. That's not the issue, though. The issue is when they come for those further approvals, is this zoning determination going to have determined the zoning issues, and the township would be precluded from denying the plan on that basis? Peter doesn't think so, but Biomed is basically saying, yeah, they're going to raise that issue. So if that is the issue, then we are clearly prejudiced. A couple other points, and then the other corollary to that, if something is a nullity or it's advisory, it seems to me it is to all parties. It's not just to one party and not another. And I think Mr. Ryan is right. If the township is stopped in some way, or this has some legal effect, then Brandywine is going to be prejudiced. Just a couple other quick points. I wanted to address the question of the final determination. The North Codorus case, which, as I said, there was a plan filed. However, the only determination in that case wasn't the final decision on the plan. It was the zoning officer saying which ordinance applied. And the court said that, yeah, that was the final determination. So the determination we have is the final determination. The final determination doesn't mean that's all the approvals you need to build the plan. It just means that's the final determination that the zoning officer has made, and whether that is appealable. I want to address the question of 916.2, which Nick had mentioned. There is a procedure, 916.2, procedure to obtain preliminary opinion. A couple points about that. One, it's totally optional. Second, if you read the language, it basically talks about, and it was written for, in order to not unreasonably delay the time when a landowner may secure assurance that the ordinance or map which proposed to build is free from challenge. So we know that the cases say that in the case of a challenge to an ordinance, you can't bring the challenge until the time of a building permit. Those cases aren't applicable here. So the MPC, this provision was added to say that's an untenable position for a landowner. I'm gonna have to wait until I get my building permit to find out if my ordinance that I'm proceeding under is invalid. So this procedure was put into the MPC, and it's totally optional. And I think what's important to note is that in the jurisdiction section, if you go down here,
We're not seeing that on our monitors.
Oh.
It's up there, but we can't really see it
Well, I'll
there.
read it. If you go down here to number 8, 909A8, appeals from the zoning officer's determination under 916.2.
Could you move it over a little bit down? They've got it on our monitors, George. And up a little. That's good, very good.
So 8, appeals from the zoning officer determination under 916.2. So that's a separate animal, optional. So if they follow that, your jurisdiction comes under 8. But it doesn't mean to say that if there's a different kind of determination, you're under 3. So it doesn't matter whether they followed that optional procedure or not. They got a determination here, and we believe it's going to be used in the future to our detriment and possibly to the township's
I'd like to
detriment.
ask you a question. How did your client receive notice of this determination?
We were at a different township meeting, and I believe Mr. Cornelia told us a determination had been made, and he gave us a copy.
So you received no notice from the township or from any of the parties directly? You weren't copied on anything, or?
No,
No.
no, but we were given it, and we appealed once we found out about it.
Thank you.
And what I'd like to address is actually the Amin case, because in the Amin case, the township ordinance mimicked 916.2. It stated almost word for word what the ordinance, what 916.2, and they said procedure to obtain preliminary opinion. In the case, it refers to it, it cites the ordinance, and the ordinance is almost word for 916.2. And that's what Amin did in that case. He actually proceeded under 916.2. And that's why the court determined that it was not an advisory opinion and that it was right for appeal. That's not what Biomed did here. They were not proceeding under 916.2. They have not sought to rule out any objectors on this, and that is why it's not right for a final determination. If we had proceeded under 916.2 and it had been advertised and the zoning officer had made a determination, then it would be right, but that's not what occurred here. This was a request for an opinion from the zoning officer, and a determination was made, but it was not a final determination. It's a subject to appeal.
The one thing Amin did, you have to get to stopping, to starting the time period against third parties, you still have to get a favorable decision.
Right.
He got as far as an unfavorable decision. One of the things that Amin says, and I've got a little issue with, is there's also a provision in their ordinance jurisdiction section, I believe it was section 111, which was a little broader or differently worded than the MPC, and they, the Commonwealth Court panel thought that that gave jurisdiction. My own read of the cases in general under the MPC is that the MPC is narrowly construed, and if the power is not specifically provided, a MPC municipality and its agencies cannot do it. So I thought that that statement was out of kilter with some of the, fairly extensive decisions like Grand Central Sanitary Landfill, for one. Zoning boards don't have the ability to alter their, to rehear cases and so forth. But to me, it was for what distinguishes a mean is it was for a specific project, and the township treated the letter as an appealable event and does not, from what I can read in the mean, never change that position. They said it from the beginning. They, the trial court was the one that interjected the advisory opinion.
Remember, that was because the ordinance provided that a mean could appeal a denial of that advisory opinion, just like you stated. I agree with you that you can't go beyond what the MPC grants, and it appears as if the ordinance did go beyond that. And perhaps that's why this is not a reportable decision. It has no precedental value. It's just there to, for argument purposes. But since you raised it.
One question is unrelated to that. Do you think that the October 4th letter is a final action by the zoning officer on the question of whether the 475,000 square foot of density can be used for office?
A final action? No, it's not a final action. A final action would only occur if a permit was granted or denied, or land development was applied for, granted or denied.
Thank you.
I would just like to make three points. First off, if Biomed had submitted an application with these exact same questions that it submitted to Mr. Kachansky to this zoning hearing board, clearly this zoning hearing board would not have the jurisdiction to review those questions because they clearly be granting an advisory opinion.
And Joe Dara says that you can't go through the zoning officer to get in front of the board that which you cannot bring directly.
Exactly. So if that's the case, then clearly Mr. Kachansky's opinion is also advisory and it cannot be appealed to you at this point. Secondly, there is absolutely no substantive relief that you can grant based on this appeal. The only thing you could do if you hear the merits is decide whether or not Mr. Kachansky made a correct or a wrong determination to the questions presented to him. After that, nothing happens. No plan gets built. No plan gets prohibited from being built.
We'd kill the estoppel argument, though.
Nothing happens.
Wouldn't a decision by this board saying that the letter was wrong on the merits make it very difficult to assert an estoppel argument?
Possibly, unless they appeal, argue that they relied on it before this decision was made.
Well,
Or possibly if they then appeal this decision ongoing. I don't, like I said, I think the estoppel argument is a red herring from a land planning and a zoning perspective, because it has absolutely nothing to do and cannot be used in an argument to say, you must grant us approvals. Whether or not something is approved is based entirely on the ordinance. And no matter what the township says or doesn't say, no matter how wrong the township is or is not, ultimately, it just is based on whether or not they comply with the applicable ordinances. So the estoppel argument for this board, for anything outside of a civil litigation in front of the Court of Common Pleas, it is a nullity because it just doesn't exist. It doesn't work.
Mr. Nelson, if Biomed submits a land development plan for 100% office use,
Yes.
and the land development plan complies with all other requirements of the zoning code, can the township deny the application on the basis that 100% office is not permitted by the applicable zoning code?
Okay, well, here, if If
If the sole basis for
Yes.
the township's denial of the permit,
assuming that the zoning code does not allow 100% office, assuming the zoning code, let's say, says you can only have no more than 90% office there, yes, the township could deny it. Absolutely. And the township would be prohibited from approving it. There's no discretion there. In a land development approval and permit approvals, there's no discretion on the part of the township. If you meet the ordinance, we must grant it. If you don't meet the ordinance, we must deny it. That's why the estoppel doesn't work.
But the question is...
no, the question is, can you say in the future that 100% office is impermissible?
Or any of the issues. Can they say, in reviewing the plan, you don't comply with section so-and-so? And you say, well, see, it doesn't comply, but are you stopped from saying that to him?
Absolutely not.
Well, I mean, I understand that's your position, but the question is Brandywine in jeopardy that could happen?
Absolutely not, because when we reviewed a plan, the review is literally our professionals, the engineer, my office, a township planner, Kevin's office. They write letters and they go through the applicable ordinance sections and list all the sections that the plan does not comply with, and says...
I understand how the process works,
right.
But what I'm saying is that the very principle of equitable estoppel that's been used against municipalities is based upon the fact that it would be unfair to allow the township to take a contrary position to one it took previously, on which people justifiably relied, who would suffer detriment should the township be allowed to reverse their position. So the very essence, if what you're saying is true, then there is no such thing as an approval by estoppel, and we all know there is. So I think with certain issues...
There's a vested right approval.
I'm not saying it applies in this case or it could be effectively asserted, but there is such an issue, and it does do exactly that. That is what the doctrine holds. So.
Although, no, the only time I've ever seen estoppel used in a zoning case is if there's like a house that's in not conformity, someone built a house and in violation of the zoning code, and the township knew about it and never did anything about it, then the township was stopped from going in and asserting. It's the only time I've ever seen estoppel used in a zoning matter.
I've seen it threatened many times.
But it's disingenuous, Nick, for you to tell us not to worry about it, because the only reason we're worrying about it is because you're preserving the question here.
Yeah, obviously I can't throw in the towel on that question. I know what you're saying, but still, what's the prejudice? What's the prejudice to Brandywine? The whole issue is, can it be...
The issue they want to contest in the future may be one that the township can't raise. And will they be a party to whatever appeal results from that? Do they ever get their day to say, here's a reason why you shouldn't approve this project because of this noncompliance or that noncompliance or this interpretation? Do they ever
would
get
by
their
filing
day?
an appeal to this board.
No, actually what
would they appeal to the board?
The subsequent decision of the zoning officer.
But the issue of whether there's an estoppel on that issue goes to the Court of Common Pleas. It doesn't come to us.
Well, if it's based on a permit, it would come to you. An appeal from the granting of a permit would come to this board. An appeal from the granting of land development or subdivision.
Presumably, in this case, it would be a denial. If the township were to deny them an approval for a reason that is covered by that letter, on grounds that are contrary to the determination, in small letters determination, in that letter, then that would be an appealable event by the applicant, which would be the owner of the property, by Biomed. But how does Brandywine, and let's say the township loses on that issue, for whatever reason, how does Brandywine ever get to raise that issue or get the protection of the ordinance?
Because Brandywine, under the MPC, has, as an aggrieved party, can either appeal that if they disagree with the board's decision, or if some other party appeals it, i.e. Biomed,
but
if it's in front of this board.
They wouldn't disagree with the non-approval. They would disagree with the court saying there was an estoppel.
But if we deny something, all right, if we deny a permit or we deny an approval, the township denies it, and Biomed appeals that denial, Brandywine, if this denial comes to this board, clearly Brandywine can show up and ask for party status and participate in that appeal. If the appeal goes to the Court of Common Pleas, Brandywine follows the normal procedures to intervene in that case, and they have a right to intervene in that case, and they can then participate in that appeal and argue why the township's decision to deny the land development approval is correct, and argue that it should be upheld. And that right, if there is any sort of estoppel argument, and it's my position that there would not be, if there is any sort of estoppel argument, that would not affect Brandywine in any way, shape, or form. And let's throw that all out, okay? Let's throw it all out and say there is no estoppel. The same process would occur, and Brandywine would go through the same steps. Nothing absolutely positively would change as to Brandywine. And I think that's what you need to focus on. It's Brandywine's appeal that we're moving to dismiss. We're saying Brandywine argument is a nullity.
Look,
because,
without beating a dead horse, let me give you
Yes.
one example. The example is this. Let's say Mr. Cornelius' client comes in for an approval, and Brandywine shows up at the hearing, Planning Commission, Board of Commissioners, and argues that the application should not be granted on the following grounds, and one of the grounds is noncompliance with one of the sections where Mr. Kachansky's letter says it would be in compliance. So the township's persuaded by that and denies. But on appeal, the township, if they lose that estoppel argument, on appeal, Brandywine has made a good argument, but they are actually being estopped indirectly through you. It's like a derivative estoppel, because the township can't raise it at that point effectively. They're not allowed to raise it, and they lose the protection of the zoning code on that issue.
You're presuming
That's
that the
another property
township
owner.
couldn't raise it, and I'm saying we could raise it.
You lose the estoppel argument.
What?
Not if you lose the estoppel argument. You
Well,
will be estopped.
We would still, but like I said, if Brandywine has an argument, if that can prove that Biomed does not comply with the ordinance, that argument wins, hands down.
Before whom?
Before anyone. Because the rules are for approving a land development is the land development must comply with the ordinance. If it doesn't comply with the ordinance, it cannot be approved.
Okay, I think we've got.
There's no, and the last point I want to make, which goes to this, is there's res judicata normally is not applied in land development cases. The fact that Kevin ruled on this sketch plan and said, okay, it looks to me like it complies, when a new plan comes in, it's going to be a different plan, it's going to be fully engineered, it's going to have 10 times as many pages on it, if not more. There will be several other documents that are going to be required as part of this whole plan approval. It's a new day. It's a new plan. Okay? There's no res judicata. That, we're looking at this plan as a brand new plan. And we're going to be reviewing it as a brand new plan. And so all these concerns that we're going to be somehow stopped in this plan review, I think, unless they can, submit a plan that is identical, and in my mind, looking at the plans they submitted, submitted identical plans, we would have to deny them because they don't comply, they don't fulfill tons of regulations. There's no res judicata, there's nothing that's going to carry through. Thank you.
Okay.
I'll be brief. You've been very patient. To me, at least from Biomed, this is totally not what we heard last time. It was a nullity. Now it's not a nullity. As I said last time, the stakes are very high. You could appreciate why. And I think you've hit the nail on the head on one of the potential things, Mr. Cutler. If it went down the way you said, Brandywine doesn't even have a right to intervene at best. In that case, I think you have to petition the court for grace to intervene. And then one of the questions is, has the township been compromised? We think the township, from what I'm hearing from Biomed now, they're going to be compromised if they're not saying they're not going to raise that issue in the future. And this determination is pretty broad encompassing. It says that plan, which had a lot of stuff on it, was permitted. The office was permitted, all of the parking, the higher height that was required, the building length, it was all permitted. So again, it's not that they don't have to go through an approval, it's once they get to that approval, what can be the real terms of denial. And our fear is that this issue is going to have said that it was determined and the township would be bound by it. And if the township is bound by it, Brandywine is extremely prejudiced. Thank you.
Okay, now we're going to take a recess to deal with necessities and then caucus for maybe 10 minutes, maybe a little more, maybe a little less. And then we'll continue the hearing with a discussion and decision. Okay, our recess is over, and I'm going to call if anybody would like to make a motion with
Mr.
regard
Chairman,
to
I'd
this.
like to make a motion. I'd like to move that the board grant the motion to dismiss for lack of jurisdiction on the grounds that the October 4, 2013 letter of Kevin Kaczynski does not constitute a final determination under the municipality's planning code.
Anyone second the motion?
Second.
All in favor, say aye.
Aye.
Any opposed? Motion's carried. The appeal is dismissed.
Thank you very much. You guys have a good night.
See everybody in April. Yeah. Thank you.